So, good morning and welcome. I'm Rick Oldenburg, Executive Director of the South Sound Plan Giving Council and co-chair of Leave 10 South Sound. And my co-chair, better half, is with us today. Evelyn, if you'll just kind of wave. Evelyn Ryberg, Senior Director of Philanthropy at Greater Tacoma Community Foundation. We want to thank everyone for coming today. Right now, we are in the middle of one of the most important weeks of the year. In 2008, the third week of October was set aside by the U.S. Congressional Resolution number 1499 as National Estate Planning Awareness Week because of the uncertainty and the amount of pain created when a person dies without a will or an estate plan. Nationally, this is a terrible statistic, but nationally, less than 40% of Americans have a will, and many of those are outdated or invalid due to changes in tax law and regulation. That means more than 60% of families will have to deal with a loved one's death using a will written by them by the state where the decedent resides. It gets more complicated when property is owned in more than one state. So, as a colleague recently wrote, confronting one's own mortality or that of a loved one can be intimidating. That said, failing to do so can harm your family, rob you of the opportunity to direct what happens to your possessions, and deprive yourself of having some of the most meaningful conversations of your entire life with those whom you love. That's why Leave 10 South Sound is sponsoring this session on basic estate planning entitled Securing Your Wishes Where There's a Will, There's a Way. The concept of Leave 10 South Sound is simple. Leave 10% behind to invest back into the community through the nonprofits and causes you supported while you were alive. After all, none of us got here on our own. We didn't build the school systems and universities that taught us. We didn't create the businesses that gave us our start in becoming self-sufficient, or the democracy we were lucky enough to be born into. That was all done by people we will never know, long before we arrived. Leave 10 South Sound encourages each person to find the things that resonate in their life. By participating in person now and leaving something behind later, help leave the world a little better than we found it. Leave 10 South Sound is ably run by 26 community volunteers made up of nonprofits, professional advisors, which are attorneys, CPAs, financial advisors, trust officers, etc., and local donors who represent Pierce, Thurston, South Mason, and North Lewis counties. They are an amazing group doing equally amazing work for our communities, and I see several of you on the call today, so please wave your hands. Let people know who you are. That would be great. Thank you. Yep. Okay. You have to turn your picture on to be seen. So thank you. And thanks again for everything that you do. Here are the protocols for today's meeting. Please keep your microphones on mute. Drop your questions into chat, and we'll cover those basically at the end. And I want to introduce you to our digital Wonder Woman, Melissa McCarthy. Melissa, will you wave? Melissa will monitor the chat and assist us in getting your questions to our presenter. Today, we are blessed to have the goodwill and willing heart of a Northwest estate planning attorney, Brianne Kampbell, who will explain the basics of estate planning in a way that is understandable and up to date. She was born and raised in Puget Sound, received her bachelor's in English literature from the University of Portland, and graduated cum laude from Seattle University School of Law. She runs a thriving legal practice in Tacoma and lives in Gig Harbor with her husband and 2 children, and she's been doing estate planning now for 20 years. Leave 10 South Sound is proud to introduce you to Brianne Kampbell. Brianne.
Hi, what a wonderful welcome. Thank you so much. I'm really happy to be here today with all of you, talking about something that is very near and dear to my heart and always on my tongue. I'm always talking about estate planning, and National Estate Planning Awareness Week, as you know, you've been told, is this week. Sometimes I wonder why it couldn't be National Estate Planning Awareness Life. We should all just be talking about it. And I find as something that I am constantly talking about and thinking about it, I think sometimes it's shocking to me how completely lacking in knowledge and information a lot of people are. And that's not to say that people are stupid or uninformed or any of those things. I find that most people in their day-to-day life are not talking about these types of things. And there's all kinds of reasons for that. We'll talk about that in a little bit. But it's so interesting to me that something that will affect all of us and impact all of us is sort of this mystery to a lot of people. And education is something that I am completely passionate about. So as Rick said, I went to school. I was studying English literature at the University of Portland, even though I knew I was going to go to law school, because deep down I always thought, if that law gig doesn't work out, I think I'll just go be a high school English, I will go and be a high school English teacher. And that was kind of my passion. But the law gig has worked out. And I've discovered now that I've been doing it for about 20 years that education is still something I'm really passionate about. So anyway, to tie all those things together, I'm so happy to be here today to talk about things. And I want to talk about a few things right off the bat. So first of all, things that we're going to talk about today sometimes are uncomfortable for people. And I try to make it something that's normal, because it is. Things like this are going to happen to us, around us, with people that we love. And so it's really good to be transparent about those things. So I'm going to actually start sharing my screen right now. And I know Rick said it, but I'll just reiterate it. If you have a question as I'm going through, please put it in the chat. Melissa will take a look at those. If it's something that we should address right away, she'll interrupt me. We'll we'll address it. And if it's something that can wait till the end, then I'll take most of the questions at the end today. And I am going to kind of zoom through some of these slides because we have a lot to do. And the other thing I wanted to say kind of right off the bat was that if you're somebody who doesn't have a ton of knowledge or information about estate planning, you're completely not alone. Rick alluded to it, but about 67% of the adult population of the United States does not have a will. That's a huge amount of people. I've been working on an educational project that I'll be sharing a lot about, not today, but in the future. And in doing that, I've done a ton of interviews with people, asking them questions, finding out the level of knowledge. And one thing that kept coming up over and over again with people was that they don't want to feel like they don't know anything about something. And that makes this process intimidating, because then it's hard for them to approach an attorney or to know who to talk to or to even know where to start. So as we go through this presentation today, there may be things that you already know. You may have your estate planning done, and if you do, you should pat yourself on the back because you are ahead of most people, as we've already discussed. If you don't have your estate planning done, then this is meant to be a 101 course about what estate planning is, why it's important, kind of the basic tenets of it. And like I said, if you already have your estate planning done, great. Some of these things are good reminders at any point in life. And I still learn stuff and think about things each time I meet with clients and talk about it. So anyway, that's it. If you have a question, there are no dumb questions, and we will progress along. So I always like to say it's really important to talk about death, taxes, and all the fun stuff because it's stuff that we all are going to deal with. You already heard a little bit about me. I think the most important things about me are that I've been doing this job for 20 years and I really care about it and the people that I assist. My biggest goal in life and in practice is to help the most amount of people that I possibly can. My typical client is what I consider a regular person. So I'm not the attorney to go to if your estate is $25 million and you need a lot of complicated tax-driven solutions and trusts and things like that. I am here for the everyday person to make this understandable and accessible, spread the word, and make sure that people have a say in what happens in their life. And then the other important thing about me, I always focus everything that I do in my practice around what matters most. And I like to know what matters most to my clients as I help them and what matters most to me as my family. I've got 2 kids and they're just the best things ever. And so I think once you have something that you can identify as what matters most to you, then the importance of estate planning really is hit home, because that's really why it's important for us to do it. So right off the bat, I want to talk about what is estate planning. A lot of people throw that term around. A lot of people have heard it, but a lot of people don't know what it actually is talking about. So I'm just going to break it down. The very most basic aspect of what estate planning is a set of documents, which I'm going to go into a little bit more detail in the next few slides. But so a set of documents is pretty much what we're talking about when we talk about estate planning. We're also talking about looking at people's estates to talk about any tax planning that they might need to do. We are looking at planning for incapacity. So if something happens to you when you're alive, but you have incapacitation issues and you need help, that's another thing that can be addressed with estate planning. We're talking about planning for your family or your friends, your charitable organizations that are important to you. All of those things are part of estate planning. One of the biggest pieces of estate planning versus having a will is that estate planning is meant to ensure that everything that you have and do works together in one cohesive plan. And I say that because we're going to talk a lot about the documents of estate planning, but then there's a whole other aspect to your life, and that's things that don't fall under your estate planning documents. So things that maybe are beneficiary designation driven, things like that. We want all the pieces to work together. So if you're working on your estate planning and you're talking about your will, you should also be looking at your beneficiary designations and making sure that everything is up to date and functioning cohesively with your overall plan. And then I would say that estate planning at its heart is really making sure that what you want to have happen, the people that you want to support and help, the way that you want to make an impact is what actually happens. And that's what your estate plan is for. So let's talk for a couple minutes about the actual documents of estate planning, because that is what most people think about when they think about estate planning. And I can tell you right off the top that the main thing that people are thinking about is a will. That's great. We're going to talk about that. Another alternative to a will is called a living trust. Both function as the main estate planning vehicle in Washington. So you could have either one and you would be just fine. And we'll talk about that. In addition to having that big basic piece of the estate plan, the will or the trust, you also want to have a few other documents that work together and protect you. So a will and a living trust are generally meant to mostly take care of things after you've passed away. But a power of attorney, a healthcare directive, and a disposition of remains, which I will go into a little more detail, are all meant to help you during your lifetime, or to provide more guidance to people in your life to help you with things that are important to you. So the will or the trust is the main document that we're talking about with estate planning. In a will or a trust, we're doing kind of the same basic function. So we're appointing somebody who could serve as your executor, or if you have a trust, as the trustee of your trust. That person is the person who's going to step in, kind of figure out what is part of your estate after something has happened to you. They're going to gather up all the pieces. They're going to value everything. They're going to see if there are any debts or expenses that need to be paid and take care of that. They're going to look to see if a final income tax return needs to be filed for you, because life is messy and death is also messy. And most of the time someone is passing away at some point during a tax year where they have not yet filed a tax return for it. And so that's something that we have to do. The executor is also looking to see if there are any estate tax issues to deal with. And I'll talk a little bit more about that later. In your will or your trust, we're also making arrangements for children. So if you have minor children, a will is one of the only ways in Washington that you are allowed to nominate and designate a guardian for your children. And for most people, that's pretty important. So a will or trust is very important. Similarly, if you have pets and you want them to be taken care of by someone in particular, the will or the trust is a great place, to make that designation known as well. And also, if you want to provide for the person who's taking your kids or your pets, the will or the trust is a great way to specify how you want that to happen. If you have minors, most of the time these days, people don't want someone under the age of 18 to inherit a large sum of money, and they can't legally anyway. But I find that most people also think that 18 is a little bit too young for somebody to be receiving a significant portion of someone's estate. So in a will or a trust, we can make provisions for the children to make sure that money is held and invested properly, that they have flexibility and the ability to be helped by the will or the trust monies that we have for them, but that they don't have total control over it. Similarly, we can also provide for people who have special needs. So if you have anyone in your life who needs more help than others with, organizing things or taking care of financial matters, or you might have someone in your life who's receiving public benefits of some sort, where if you took a big piece of your estate and just handed it to them outright, it would disrupt the assistance that they're already receiving. Generally, that's not a good thing for people. So we can always plan around that type of thing in your will or your trust. And then kind of the main job of your will or your trust, as you already know, is to say how your estate will pass. So if something happens to me, I'm going to say who I want things to go to. I'm going to say in what percentages. If I have charitable organizations that I've been working with over the course of my life, I don't want to leave them out. And you know, coinciding with the Leave 10, that's a place that we can designate how much the charitable organization is going to get. We always want to provide alternate options for everything that we do too. So anytime you're naming an executor, I'm going to say, and what happens if something happens to that person? Who's the next right person to step into their shoes and take over that job? And what if something has happened to both of the first two people that you've named? Who's another person that could step in and help make decisions and handle your estate? Because one thing that I've learned with estate planning, well, a few things. One is that people have the best of intentions, to do it. And then when they finally do, they have the best of intentions to keep it updated and to review it. But chances are good, if you're like most people, that once you get your estate planning done, you're going to put it away. You're going to feel a huge sense of relief, and then you're not going to think about it for a long time. My job is to remind you to think about it, but my other job is to make sure that when we're doing the planning for you, I'm asking you all these questions about alternate people and what if this and what if that, because if you are like most people and you put your plan on the shelf and you don't come back to it for many, many years, we still have a plan that will have the ability to work. It may not be all your first choices, but we've named a bunch of alternates and it will work. So that's a big part of having a will or a trust. And I've already touched on the charitable organization piece, but I can tell you from experience that if you think that you can tell your family members, okay, if something happens to me, of course I'm leaving my estate to all of you, but I really want you to make sure that you take some of the money that you get from me and you support this organization that I fully believe in and I've been supporting my whole life. And your family members are like, oh yeah, for sure. We're going to totally do that. Don't worry, mom, we're going to take care of that for you. Okay. That's like something I see all the time. I can pretty much guarantee you that once the distributions have been made to your beneficiaries, they will either forget or conveniently forget that they have made this agreement with you, and they will go on about their way, and they will probably not, a very small percentage do, but probably not go ahead and support that charitable organization because they may have other organizations that are important to them. And when someone has received a gift is a gift, it becomes theirs, and there is no legal obligation for them to do anything further with that gift. So if you want something like that to happen, the best place to put that is officially in your will and make it known. Okay, so we've talked about the will or the trust, the main document, the meat and potatoes, telling everybody what you're going to do. A document that I think is just as valuable, if not more, is called a durable power of attorney. That's a document that lets you appoint somebody else, and of course, a list of alternates, to step in and make two different types of decisions for you if you're alive, but you're not able to make decisions for yourself. So I always use the most catastrophic examples because they stick in people's minds. But if you are in a car accident and you are in a coma and you are in the hospital, we need someone to step in and consent to treatment for you. Let's say at the same time that you're in a coma in the hospital, your mortgage payment needs to be made and you write checks every month for your mortgage. Well, somebody needs to be authorized to step in and write that check on your behalf and send it off to your mortgage company so that while you're dealing with your health, your house is not being foreclosed on. The person who's named in your power of attorney can do those things for you. They have really broad decision-making power for you. And basically, I like to think of it as the person who you name, we call it an agent in a power of attorney. The person who you name as your agent can step into your legal shoes and sign anything on your behalf that you would have personally been able to sign off for yourself, or do anything legally or healthcare related that you could do for yourself. So it's a really, really important role. There's typically two types of times when these documents are effective. So you can either make it effective only if you're not able to make decisions for yourself. That's the most common way to have a power of attorney be effective, mostly because we don't want to sign a power of attorney and then have someone have the right to go around doing our business for us without telling us about it. And maybe they're working at cross purposes from us. So typically it's only available or effective if you're not available to make decisions for yourself. But in certain circumstances, it makes sense to have it be effective immediately. Some of those circumstances are if you've been diagnosed to have an illness that's going to be progressing and you need someone now to step in, and you don't want them to have to get a doctor's, written note that you're not able to make decisions for yourself. You just want them to take over now. Then immediately is when your document would be effective. I always say this document is almost more important than the will because it affects you while you're alive. It's letting you express who you think would do the best job to step in and make decisions for you. And I don't know about you, but that's not something I would want to leave to chance. I don't want to just see, oh, I wonder who will step up and do that job for me. It might not be the person that you want. So it's making sure that you pick the person. It's also making sure that the person that you pick is empowered with enough of the powers that they'll need to kind of keep your life running. So the business aspects of your life running, and then tend to your healthcare, which is really important. I do like to always point out that powers of attorney do not overlap with wills because a power of attorney is effective only while you're alive. When you pass away, it terminates immediately, and then your will takes over from there. So they come right up to each other, but they don't overlap at all. The next document that usually is part of an estate planning package is a healthcare directive. And this document is very limited in scope in Washington. It's a document that lets you tell the person who you've named to make healthcare decisions for you. If I'm at the very end stages of life, so either I'm terminally ill and I have no hope of recovering and every single thing is shutting down, it's just the very, very end stages of a terminal illness, or I've been diagnosed by 2 doctors to have no brain activity and no hope of recovering it. So that's the situation that we're in when this document would come into play. And at that point, this document lets you say whether you want the people who are making healthcare decisions for you to just keep trying everything, keep you hooked up, keep you on life-sustaining treatment kind of indefinitely, even though it may prohibit you from passing away. Or if you want the person making your healthcare decisions to make decisions that will keep you comfortable, but will allow you to pass away. So that's the whole purpose of this document. It does not take the place of the power of attorney because it's really just allowing you to express one finite decision that you want your agent under your power of attorney to make for you in the event that you're not able to voice that decision yourself. And then rounding out all the fun documents, we've got the disposition of remains. This is a document that tells the people who are left whether you want to be cremated, buried. A new option these days is composting, but it lets you tell them what you want. It also allows a funeral home to honor your wishes without having to track down every single near and dear person to you to sign off on an authorization. So in Washington, the default has always been burial as a form of disposition. And so if you want another form, it either requires everyone who loves you to sign off on something or something that you've signed and had witnessed that a funeral home can honor. So that's why we think it's important. It just simplifies the process for your family members at a time when maybe things are already difficult and they don't want to be tracking down, a million people to sign off on something when they know the answer and they know what you want. So those are pretty much the documents that we talk about when we're talking about estate planning. Of course, there are other things. There's a whole universe of estate planning documents out there, but these are the basic ones that every person should have pretty much no matter what. And that's answering this slide of who needs to do estate planning. It's everyone. You could be rich, you could be poor, you could have kids, you could have no kids, you could have pets, you could be single, you could be married, you could have a partner, you could live with somebody, you could own real estate, you could not own real estate. All of those situations lead to you still needing to have these documents, mostly just to be very clear with what you want to have happen with your estate. And I do always like to point out, I think I hit on it again a little bit later here too, but I do like to point out that people often think, well, I don't have a lot of money, so I don't think I really need to have a will. It's probably not important. And in my mind, one of the most important times to have a will is if you don't have a lot of money, because the process after you pass away, if you don't have a will, can be significantly more time consuming, which generally translates into being significantly more expensive. And a smaller estate can less afford those types of expenses. So I just like to point that out. And then the other one I hear a lot is I don't have kids, so I don't really need to have a will. And in my opinion, not having kids means you even more have to have a will, because the one size fits all estate plan that the state has for you, if you don't have a will, probably won't be fitting you, or not in the way that you want it to. So, and kind of feeding into that, people have heard all kinds of rumors about estate planning. I hear the funniest things in my office every day. People call me up and say, well, I was just talking to my mailman and he was telling me that his sister's brother told him that we have to blah, blah, blah. And they call me and they say, do I need to do that? And like, first of all, when someone is telling you something about estate planning, just like anything else, I'm not talking to kindergartners, I promise you. It's just, I hear this all the time. So if I can save you a little bit of trauma, then I want to. So first of all, consider the source. Is this person someone who has information about estate planning that is beyond the information that you have, or the attorney that you've hired to help you? Probably not. Second, consider where the person who's giving the advice lives, because every single state has different rules and laws that apply to estate planning. And some of the states that are closest to us, the biggest one being California, have completely different systems than we do when it comes to probate, which is the process that happens after someone passes away. And so what would work and be just run-of-the-mill peanut butter and jelly in California is not the same as what we have in Washington. And just an aside, in Washington, our legislature and government have done, I would say, an excellent job of simplifying the probate process here and making it a system that people can navigate. Many people don't want to, they want to hire someone to help them. But if you wanted to, it is possible to do it. It's also in our state very important with the government that attorneys don't get to charge a percentage of the value of the estate, and neither do executors. They want it to be simple and straightforward. And so I'm telling you this because one thing that people hear all the time is that you absolutely have to have a living trust. And typically that is coming from people who have lived in California or have friends and family in California. And in California, that is 100% the truth. In Washington, a living trust can still be a great idea under different circumstances. I'll go into those later, but it's not necessary. And the main reason it's not absolutely necessary in Washington to have a living trust is because our government has said, once a probate is open and once a person has been appointed as an executor, we want our probate system to look and function like the administration of a trust. So they have basically just put those two things together in our probate system, which is great for us in Washington. It means maybe you don't have to have the most complicated thing in the world to still have it work really well for you. So you may have heard a ton of rumors. We've already touched on some of them. My favorites are you have to have a trust, because that's not always the truth. Only rich people do estate planning. Only people with kids do estate planning. I can just handwrite my own will. Like, I've got a really handy napkin right here, and I'm just gonna write down what I want. People tell me that all the time. Well, we went on a trip. I'll say, oh, do you have estate planning that you've done before? Because I want to see what they've done if they've done it before. And sometimes people will say, well, just what I wrote up, but it probably could be better. It's like in Washington, a handwritten will may be possible to have one that's effective, but not likely. So I would just not go that route. Another really favorite rumor of mine is the state will get all your money if you don't do your estate planning, which is actually not the case. Which is a relief, but also not a reason not to do your estate planning. It's just that maybe one of your relatives that you don't care about that much or that you're not close to might end up with your estate instead of the state. So some good rumors. Why is a plan so important? A plan is important, like many things in life, because it serves as a roadmap to get us from where we are to where we want to be, right? And in the case of estate planning, it's getting us from where we are. It's getting the people that we love to the place that we want them to get to, and the assets that we have and care about to the place that we want them to get to. And that's important. It's important for you to make your own decisions about things and express them. I'd say that's probably number one. But there's a whole lot of other important reasons. So it's simplifying the process for people who you care about. It's making your ideas clear. It's not leaving ambiguity for people. It's making sure that organizations that you care about are supported properly the way that you want them to be. And just making sure that the people in your life are cared for in the way that you know that they need to be cared for. So no one knows our family members better than we do, right? Nobody understands their strengths better. Nobody understands their weaknesses better. And that makes us in a unique position to care for those people. And I have a lot of people come in where they're like, I love this person, I want to provide for them, but I just know if I leave everything to them, that's not going to be healthy for them. Or if I leave everything outright to them, they're not going to know what to do with it. They're not going to know who to ask. They're not going to know that they should go see a financial planner and have money invested, right? So all of these things come into play. And while one of my huge soapboxes is keep everything as simple as possible because it's easier for people to execute it if it's simple, we also can take all this information that you know about the people that you love and make sure that things are structured in a way that will work for them and you don't have to worry. So plan's important for all of those reasons. I would say, even though I just said making your own decisions is probably the most important, I think probably the most important over all of this is the peace of mind that you will get when you do this. I have not had one client ever in my 20 years who left and said like, wow, I feel even worse now than when I started. They are all leaving the office like, wow, that was so much better than I thought it would be. I have such a huge sense of relief. I can tell a lot of them feel accomplished. You know, it's something that's been on their checklist for a long time. And when things stay on your checklist for a long time, they tend to just add weight and gravity to you. And so when you can release yourself of one of those things, especially something kind of in the serious side, it just makes you feel so much better. So I'd say, number one, give yourself the gift of peace of mind, and then give your family members the gift of clarity. So knowing all of that, why do we avoid doing this? Why do people avoid this? It's complicated. It's so complicated. I think the biggest reason people avoid it is because it seems like something that's not immediately necessary to them. And hand in hand with that is not knowing that it's necessary or how to know if it's necessary. So number one, I think is just, you know, like, oh, I could put this off. Things are going to go on forever. It was a really interesting psychological experiment if you could separate yourself from reality during COVID, and just in my position as an attorney, watch what happened when COVID happened, because this is always just a very steady area of the law, right? People always need estate planning, so I'm always talking about it. I've always got a busy calendar, but COVID happened and it was like 4 times the amount of calls that we would get were coming in. And I just have to attribute that to my informal decision that people decided, oh, like maybe something might actually happen to me. Maybe this is actually important. So for that one reason, I think there were some silver linings to COVID, just maybe bringing it to mind, like, okay, I could actually get my stuff in order at this point. But beyond just not knowing if it applies to you, I think fear is also a huge driver in people not wanting to talk about this. We don't want to talk about passing away. You know, it's a big unknown for a lot of people. We don't want to talk about our family members dying, and we don't want to talk to our family members about them or us dying. And I can tell you from personal experience, I talk about death and taxes and uncomfortable situations day in and day out. But if I am talking to you about my children or my parents in relation to estate planning, I am a basket case, which is why I will say no more than that. I've had these conversations with my parents, and even though I can put on my professional hat and try to treat it like that, I just can't on the inside. And so I do really understand where people are coming from here, which is why I think attorneys are a safe place, because we're not the people that you care about the most. And when you come and talk to us, we can make it more comfortable for you. And it is something that we should open the door and talk about more. I had a client the other day. We had a really great conversation. We went through all of, the questions and the answers and got our way on getting a plan started. And then she called me about 2 weeks later and she's like, well, I've been really struggling with a couple of these homework items that I have. And I find it really interesting that people don't talk about this stuff more. I think in a culture where we're all going to deal with it, we're surrounded by it, it's so interesting that it's so hard to do these things because we just don't have enough information and it's awkward to talk about. So if I can do anything, I would say like maybe throw this out at the dinner table sometime and just see what happens with it. But you want to keep reminding people about it. You want to keep talking about it. Other reasons that it's really easy to avoid doing estate planning is because people have complicated families and complicated relationships. People have questions about taxes and they don't even know where to start on that. So they just like, I'll just deal with that tomorrow. I don't know anything about that. Maybe they know things are complicated. They've got real estate in another state. They've got real estate here. They've got all kinds of different accounts. And they're like, that is just going to be a lot of work for me to try to figure this out. So again, I'm just going to put that off until tomorrow. And then again, it's so crazy, but also not, that most people don't have a will that would work. One thing also I like to just kind of talk about real quickly in this conversation is what in the heck is probate? Because probate is completely interrelated with wills and trusts. Probate is the process after someone has passed away of taking all of those pieces that are all over the place and putting them into order, making the puzzle complete, and then pushing it out to the next people. So from a very technical standpoint, probate is a formal court process of having either the will accepted and the executor appointed, or if you don't have a will, having a judge approve a person who's asking to be the executor or the personal representative of someone's estate, getting that person appointed, figuring out anything that the person who passed away owned, and figuring out anything that they owed as of their date of death. So we call that the inventory. It's a snapshot just as of the date of death. What did they have? What did they owe? Does what they have equal out to more than what they owe, or vice versa? That changes the process a little bit. Probate is then transferring what you have to the people that you want to get it, wrapping up all the loose ends, and filing any final tax returns that have to be done. That's probate. For the most part, people are only going to deal with, when they're dealing with taxes, an income tax return for the person who's passed away. In some cases, there will be an estate tax return, and there's a lot of confusion about estate taxes as well. And I'm just going to give you like the bird's eye view of estate taxes. So there are two levels of estate taxation that apply to people who live in Washington. There's the federal level, which is carried out by the IRS. That estate tax does not hit your estate if your estate is under $12 million. That's today's number. In 2025, that number is set to go down to $6 million if government doesn't do anything, and who the heck knows if they'll do anything. But regardless, if your estate is 12 million now, $6 million later or under, there would be no federal estate tax, which is good because the federal estate tax, which covers everything above that exemption amount, is high. It's around 30% or 40% of your estate. So we don't want to have that apply to your estate. The other estate tax that applies to Washingtonians is the Washington state estate tax. And unfortunately, our estate tax exemption, so the amount you can have in your estate without paying estate taxes, is lower than the federal government. But then also our tax rate is lower too. So our exemption amount is 2.193 million right now. It's not set to increase or change at any point in the future. I would anticipate that it will, because it's been set at this number for a very long time. And actually, it was supposed to be moving up every year with inflation, but the way that they wrote the law meant that at some point that increase ended and we're stuck with 2.193. So that's where we are now. If your estate is under that, you've got no estate tax issues. If your estate is over that, your estate may pay 10 to 20% of the amount that's above the estate tax exemption. But all those things are part of the probate process. So when we're going through it, we're figuring all that stuff out. That's why it's important to know what you have and what you owe, so we understand what the size of your estate is, and then just wrapping up all the other loose ends. When is probate required? So again, I'm just going to hit this one pretty quickly. But basically, if your estate is over $100,000 in assets that are subject to probate, so assets that are subject to probate means something that you own that's in your name that does not have another way to transfer. So if you have a bank account in your name, let's say it's a money market, and you're you're saving for the best vacation ever, and you've got like $100,000 in that account. Money markets typically don't let you have a beneficiary listed. So that account would be an asset subject to probate. The other really big category of assets subject to probate is real estate. And if you own real estate in your name in the state of Washington, your estate is subject to probate. I wrote here, if no other forms of transfer apply. So that'd be like you have a retirement account that's $300,000, but you have a beneficiary listed on that retirement account. That's going to go to your beneficiary, and it's not subject to the probate process. It's not answering the question of if we need to probate or not. When is probate required? When you have a will, when you don't have a will. If you meet that over the $100,000 or real estate, there will be a probate most likely, and it happens whether you have a will or not. You can probably guess that the probate where there's a will that's effective and is admitted to probate is going to be a less expensive and less time-consuming probate than a probate where there's no will to tell people what to do, or the will is so outdated it doesn't really work anymore for what we need it to do. And then the other situation where a probate would be required too is when someone has a living trust. Most of the time, the purpose of the living trust is so that they can take assets that would otherwise go to probate, put them in the trust, and then that way, when they pass away, their estate is not going to go through the probate process. The trust itself is going to take care of all of those homework items that we have to do to get the estate wrapped up. But oftentimes with living trusts, people set them up, they've got the best of intentions, they put it on the shelf, just like I talked about, and then they go through life. And what do we do when we go through life? We change everything, right? Everything is constantly changing in our lives. We sell our houses, we buy new houses, we open accounts, we close accounts, we move between states, we do life. Life is messy, life has changed. If you have a living trust and you go through life making changes and you don't keep that trust at the forefront and make sure that all the changes that you're making, you have that trust in mind, then the problem is that when you pass away, even though you have a living trust, some of the stuff that you have has ended up in your name instead of in the name of the trust. And now we're back to going through the probate process. I do like to just mention, and I think I did before too, that even though probate is a process, it is not a nightmare. It is a nightmare if you have people who don't get along. If you don't have a will and there's a lot of loose ends in your life, it could be a nightmare. If you have a lot of creditors and the creditors exceed the amount of the value of your estate, then probate could be complicated, but of course it could. Generally, other than that, probate is just a process that you go through to do all of those things that we've talked about that you know you have to do when someone passes away. Or you'll learn that you have to do when someone passes away, but it's not a nightmare in and of itself. And like I said, our probate process here has really been structured to be as clear as possible, not time consuming, and hopefully not expensive. So if you find out that your estate is going to probate, please don't freak out. It is okay. And the other thing I'd like to say is because our probate system here is based on the administration of a trust, kind of the same process, it means that even if you have a living trust and you've done all of your due diligence to keep it up to date, it may create some shortcuts, but it doesn't mean that you do nothing when the person passes away. That's a huge rumor that people have heard, is that if I have a trust, then if something happens to me, my beneficiaries are set. Everything is just going to like magically go where it's supposed to go, and I'm not going to have to do anything. And because people have heard that so many times, I have a lot of like reality setting meetings with people where I just have to say, I know that this process is going to be easier than it would have been otherwise, but I also know that there's going to be at least one thing that comes up that's going to really irritate you, because there's no way to get through this process of dealing with financial institutions, banks, filing tax returns, dealing with beneficiaries, people who may be like great to deal with, sometimes not, right? There's no way to get through this process, even if you've done everything completely right. That will just be, I'm doing nothing. There will be work for the person who's the executor or the trustee, but you can lighten the load by making sure your documents are taken care of, they're straightforward, and they're up to date. So that's kind of my 2 cents about probate. You don't have to freak out, but the more that you can do on the life side of things to make it clear cut for people, the better, more easy time that people will have on the death side, which is, I think, our goal. I don't think any of us really wants to like die and then have people just mad at us because we left a huge mess. Our house is a mess. Our finances are a mess. There's no will. I don't know who should be appointed. None of us want that. So there are things you can do that are not difficult. And then I just want to touch too briefly on, we did already kind of talk about this a little bit, but other ways things can transfer besides using a will to transfer it or having things in a trust where the trust is taking care of it. There are really simple ways of transferring things too that most people know and have some of these things already. But if you are a joint owner of an account with somebody, typically what that means is that if you die, they inherit the account, the joint owner gets it. So that's a way of doing it. Another way is if you're married, you can have a community property agreement. And that means that basically what you're saying is, I don't care if what I have is separate property or community property. When I die, I just want it to all be looked at like community property, which in Washington means it will transfer to my spouse. A big rumor that people have heard is that because we live in a community property state and they're married, there would never be a probate when their spouse passed away. And that is absolutely not the case. If you have a community property agreement, that could be the case, but community property agreements are good for some people and not good for other people. So that's something you should talk to a professional about. If you have a trust, maybe you wouldn't have to go through probate. But if you and your spouse own real estate together and both your names are on it and you don't have a community property agreement, chances are we may have to open a probate, a short, easy probate to just get everything cleaned up at the death of your spouse. Another way that things can transfer is through beneficiary designation. So just like we said, when you sign up for an insurance policy or you sign up for a retirement account, they're generally wanting you to list, if something happened to you, who do you want this account to go to? And you can often list more than one person. So let's say I'm a single mom and I want both my kids to get my accounts, and they're both in their 30s. So I don't need to worry about any type of special, help for them. So I just list both of them as 50-50 beneficiaries of my account. If something happens to me, that account doesn't have to go through the probate process. They're just going to file my death certificate and then the assets are going to pass to them. So that's a really kind of nice, easy way to transfer things. Same with transfer on death or payable on death clauses. And then trust, we talked about trust, but a trust is a way that you can transfer things to without the need for the probate process. And then kind of a big question that people are always asking, and I don't want to go into it too far because I don't think I said this before, but I'm not your attorney. I'm here just giving you general information. If you want me to be your attorney, you can call me and we can definitely arrange that. But for right now, I don't know anything about your situation. And every single person, every single estate is different for so many reasons that it's really hard for anyone ever. And you should be suspicious if they try to give you a one-size-fits-all answer to any of these questions. It just really isn't possible. And after 20 years, I can say that wholeheartedly. There's no one-size-fits-all for everybody. Should you have a will or a trust? I can't tell you that answer. One of the benefits of having a living trust, like we talked about, is that if it's done properly and it's funded properly, and then you live your life remembering that you have a trust and maintaining it properly, and you're into homework, then your living trust may be perfect for you and may avoid the probate process. That's the benefit of the trust. The trust does not do anything for you from a tax perspective. So there are types of trusts that you can set up that do help from a tax perspective. A living trust, which is what most people think about when they're talking about trust and estate planning, is not going to do that. A living trust uses your social security number, which means when it comes to the government and to liability and to taxes, it's yours. So no tax savings, but you could avoid probate. There are certain situations where a trust would work better than a will for you. And the biggest one in my mind is when you have property in another state, but you live in Washington. So in that case, states only have jurisdiction over what is owned in their state. So let's say I live in Washington and I've got a killer condo in California. I'm so excited about it. I love to go there. I should have a trust because A, California is horrible for probate. And B, if I pass away, Washington law is not going to take care of that condo in California. We have to open probate here in Washington because this is where I live. and deal with my stuff here. But then we've got to hire an attorney in California and have them open a side-by-side probate in California. And so you can imagine dealing with a probate in Washington and having one attorney assist you and our great laws. That's one situation. Having a probate in Washington and having to hire another attorney in another state and deal with their laws and their fees and their expenses, that's not a good idea. So having real estate in 2 states, you should 100% think about a trust and at least be advised about it. If you're really, really interested in not going through the probate process and you want to try to simplify things for your heirs, then having a living trust might work for you, but you have to be prepared to be diligent with it. And if you are, it can be great. That's kind of going to the maintenance thing too. And then some people come in and they like the idea of the trust, but they just want to keep things simple. And they say that over and over again to me. I just want things to be as simple as possible. I just want it to be as simple as possible. I typically find that if you want things to be as simple as possible, then a really straightforward will is always going to be simpler than a trust, only because wills are more commonly understood by people and trusts are just a little bit more out of the ordinary for people. And so when you're asking someone to step in and settle your estate, they may feel a little more overwhelmed dealing with a trust versus a will. But the converse of that is true too. And there's no perfect answer. If you have either one of these things in Washington, it is going to work for you if it's, you signed it properly and it's been kept up to date as much as you can, and it has flexible provisions built into it, and it will almost always be better than having nothing. So you should have one of them. Should I have a will or a trust? Yes, you should have one. Who should be part of this process? I think this is kind of the last thing we're going to touch on today from a substantive perspective, and then I'm going to open it up to questions. This is a question I don't think people think about that often. But when you think about doing your estate planning, of course, you are the most important person. If you cannot afford an attorney and doing a will with an attorney is way out of your purview, you and LegalZoom can get something done. You may not be happy with the result of it, may have some complications in it. I find a lot of times with people, what the feedback is that I hear from people is they don't know how to answer the questions because they don't know what the questions are about, really. They don't have enough education. So you are the primary person involved in this process. And if you really need to, you can find a way to do this without using an attorney. But the other most important person in estate planning is an attorney to help you, to ask the right questions, to answer your questions for you, to talk you through different scenarios, to tell you that it's going to be okay. Probate is not a nightmare, and answer the process type things too. What does this look like? What does that look like? Okay, let's say this is your scenario. Let's run through this, because I have seen so many different things just in my everyday experience that most people haven't. I do have a different perspective on people's plans than they do if they haven't talked to me. But then besides the two of us, you and me, in addition to that, if you have a financial planner that you work with, if you have a CPA that you work with, if you're really tied in a bank and you've got a personal banker, those people are also really important to loop in on this process for many reasons. First of all, sometimes they have a better understanding, imagine that, of your financial picture than you do. And sometimes they have concerns for you because of their relationship with you, and they understand your family dynamics and they know your financial picture. They might have some really important things to bring to the table. The other thing that you should think about is if you want to leave a gift for charitable organizations, bringing in the charitable officer from that organization is ultra important. And when I say bringing people into this, I don't mean that we all have to sit at a table and have a long meeting. That's fun. If we can do that, I love that. I love talking to other professionals. I love knowing that we're all on the same page. But we don't have to do it like that. You and I can meet, or you and your attorney can meet, and then we can just reach out to these people that know things about you and make sure that we've got all the important information. And then vice versa. When you have your documents done, we can let them know what you have so that they know, what they need to do. If it's a financial advisor for you, they can make sure that your accounts are all lined up and that your beneficiary designations have been taken care of. If you've got minors and we're trying to put some type of a trust structure into your will for minors if they inherit, And then you've got these retirement accounts, and you want your kids to be beneficiaries of that. We want to work with your financial advisor to make sure that your beneficiary designations and your will and the trust we're creating will all work together, and that you're not going to have something happen with your financial accounts that's going to circumvent the plan that we're putting in place. So it's usually my preference that we make an email kind of outreach. Sometimes people who are really close to you, that you work with really closely, advisors, they want to sit in on the first meeting, either by phone or in person. That's great. But then just keeping everyone in the loop is really important. And I think also a really important part of making sure that your documents stay maintained over time, because these people, if they understand your objectives and then they've helped a little bit initially, as time goes on and things change for you, they can also be a person, a backstop to say, hey, you might, this just happened. Why don't you think about talking to your attorney about updating your estate plan right now? Because I know this is going to affect the plan that we talked about 10 years ago. It's changed now. So anyway, attorneys shouldn't want to be working in a vacuum, and you shouldn't either. You should want kind of your whole team, if you have people on your team, to just know everything, because we all do a tiny slice of the whole, and we want the whole to be represented. So that's about all I have for today on the 101. It was a whirlwind. I hope that no matter what, no matter your level of experience, you learned something, you had some kind of reminder, just something valuable. I think a refresher on estate planning and kind of a lot of things is important as we go through life. So hopefully this sparked something for you. And then if anybody does have any questions, I'm happy to take them now. Melissa, have you seen anything come in the chat?
We do have a couple questions in the chat. The first one was, what if I have an LLC and it contains property in other states? Will that work as well as a living trust?
So the LLC is great to hold property in other states, because that's right, that will circumvent the probate process in the other state. But your transfer of a limited liability company interest is a probatable transfer. So definitely helps with the out-of-state issue. But it may not get you out of the probate issue.
Great. Our next question was, can you explain how to set up a TOD/POD?
So typically, typically that would be something that would be offered to you. If you were at a bank setting up an account, usually those are the types of accounts that I see, those types of designations, although there's some financial advisors on here too that might be able to pipe in and answer that question too. But typically, I think when you're signing up for the account, that would be an option that they'd be giving to you is, oh, you have a transfer on death option for this account, so let's use it. Who do you want to list? Kind of like when you're setting up beneficiary designations.
While we have a break here, thank you, Brienne. What a wonderful gift you've given everybody today. And I would love everyone who's still on the program, if you would put your screen on, and let's give Brienne a great big air applause. I mean, it's like an air guitar, but it's applause instead. So done, wonderfully done. And we've got lots of time for questions here. I did want to point out that this program was the brainchild of Leave 10 South Sound Community Outreach Committee, some of whom are on the link with us. So those of you who are, if you would make your faces visible and please wave when I read your name. Co-chairs are Sherry Stanton, KBTC Public Television, and Sharana Kildun of Habitat of Humanity, or for Humanity. And then committee members, Regina Bellady of U.S. Bank, Vicki Brummond, Plan Giving Marketing Specialist, Hella Burlingame from Evergreen State College, and also from Thurston County, Mike Christensen, South Puget Sound Community College. Beverly Cox, B. Cox Planning in Gig Harbor, Katie Evans, Hilltop Artists, Brenda Gaspar, Korean Women's Association, Kurt Jacobson, Community Volunteer and Marketing Specialist, and Carol Kowalski, Kitsap Bank. And finally, but not least, Carrie Young, Lutheran Community Services Northwest. And I might add that co-chairs, myself and Evelyn Ryberg, we're on every committee, but we don't take any credit for this. This is their deal. Any more questions? Let's flip it back to questions.
I see a couple more questions. So there's a question about if a probate isn't a percentage of assets, so the probate fees aren't a percentage of assets, what would be the average cost of probate here in Washington? And then there's a couple examples of whether it's a $2.5 million estate, whether it's 4 million. So I see kind of two different questions here. One is, what would probate fees be? And in Washington, attorneys are pretty much just allowed to charge their hourly rate for the actual amount of hours that they've spent working on a case. So it wouldn't matter if the estate was 2.5 million or 4 million or 10 million. It just depends on the work that's required. And I've had cases where we're dealing with a $10 million estate, and aside from needing to have a CPA to step in and help prepare estate tax returns, everything else was super simple. And so it was one of the least expensive probates that we've ever had as far as attorney fees go. Estates that have people contesting things, other attorneys who appear and want to have a lot of different documentation, those are cases where you might see higher attorney fees. I would say a good average, we tell people this average in our office all the time, because over the past 20 years, I keep track and add every single finished probate attorney fees into a spreadsheet so I can have a good average range to show people. And over time, of course, things have come up as inflation has risen, but right now, I'd say a really good range that you could expect to pay for a probate would be maybe somewhere between $5,000 and $6,000 and $7,000 and $8,000, depending on the complexity. So if it's really complex, it's going to be above that for sure. If there are people who are fighting about something and there's a lawsuit that's going on, that range doesn't apply at all. Lawsuits are the most draining thing on an estate, period. But if it's super simple, sometimes it's much less than the range that I'm giving. But usually that's a pretty solid range for just a run of the mill. There's stuff to deal with, there's stuff not to deal with. Yeah. And then someone said, if assets are placed in a trust, do they have to be used to first pay for the deceased's debt? That's kind of an up in the air question. Typically, when someone has passed away, anything that's part of their estate, whether it's in their living trust or it's in their probate estate, is going to be subject to their debts. The exception to that, and there's caveats to everything, but the main exception to having assets be subject to debt is what type of an asset it is. And assets that retirement account assets and insurance policy assets that transfer from the financial institution directly to your beneficiary are insulated oftentimes from creditor claim issues. And so in addition to making things easier to handle for people, when you've passed away by using your beneficiary designations, you're actually also getting a level of asset protection by doing that, because it's really hard for a creditor to come in and try to argue that they should have a piece of your retirement account that went already to somebody, or a life insurance policy, and they stand in a protected class of assets too. But yeah, generally assets of the estate, whether it's in a living trust or whether it's in the estate itself, are going to be subject to payment of the debt of your estate. I guess I would add one thing to that too, because it's a big question people ask. When someone is appointed as your executor, do they become liable personally for your debt, the estate debt? And the answer is no. People who serve as personal representatives are liable to do a good job and make sure that the estate, takes care of its debts as much as it can. But if the debt of the estate is bigger than the assets of the estate, we go through kind of a mini bankruptcy proceeding within the probate, and then the rest of the debt is discharged. And the person who's the personal representative doesn't have to personally pay any of that. So again, there's caveats to everything. If the personal representative has taken money from the estate and not paid debts, then yes, they could be personally liable for it. But for most people, no. Okay, I'm here representing a nonprofit in Olympia, and we have an out-of-state donor wanting to include us in her will. What considerations should we have? It doesn't really matter where your donor is if they want to include you in their will. The laws of the state where they live will govern if her will is valid or not. But other than that, you can make donations to any person that you want or any charitable organization that you want, and it doesn't really matter which state they're coming from. Emphasize the importance of communication. Okay. Yeah, so thank you, Evelyn. Evelyn reminded me about a topic that is also near and dear to my heart, and that's transparency. So when you are making your plans and your will, you can do whatever you want with your assets. You could say, I don't care. My kids are pretty well taken care of. And also they're kind of rude. And I want to leave everything in my estate to the Humane Society because I think they're amazing. Animals are my passion. And I just don't care. You can do that. That is up to you. As long as you're of sound mind and no one is forcing you to do it, it's totally fine to do that. The kind of blowback that you might receive if no one in your family knows that that's your plan, and then you've like told them all along, like, oh yeah, you guys are gonna get, thirds of my estate, and I've taken care of you, and then you die, and the Humane Society is your beneficiary and not your kids. There will be a will contest for sure. And so what that's a very extreme example. There's oftentimes examples where like a parent says, well, I've got 3 children and one is just doing so much better than the others. They don't need my help, but the other 2 do. So they might leave less to one versus the other. And there's a million different scenarios where your plan may not be super popular with your family members. I can just say that you don't have to tell them ahead of time if you do that. And some people are like, nope, I can never tell them about this, but this is what I want to do. And then I just do my best to document the file, knowing that a big problem is coming down the road. So my advice always is be transparent. Tell people what you're doing. Make sure when you're telling them what you're doing, that is actually what's in your documents and you understand your documents. Don't lead people on. Don't tell them things that aren't going to be the truth. If anything, just say nothing, I guess. But if you can be transparent, and especially if you can be transparent over time, I have found that even when people don't like your plan, they've heard it so many times, and so is everyone else, that they know that that's what's going to happen. And they're not. Surprise and grief and money are a horrible combination of things. Don't put your family in that position.
We don't have any questions in the YouTube live stream chat, but we did get a message of thanks, and they said that it was a very informative presentation. So
Awesome.
I wanted to, if you don't mind, I wanted to butt in and ask if you would go back to that question that talked about the 2.1 million and the 4 million for the family. If you would go back, I think you said that's 2 questions, and I think you answered the first one, but not the second one.
Yeah. So my other train was that was leading more to a difference in what type of estate tax would be paid on those estates. So in either case, the $2.5 million estate or $4 million estate, there's never going to be, well, in our purview, there's not going to be a federal estate tax. There would probably be a Washington state estate tax assessed on the $2.5 million. And there would be a Washington estate tax assessed on the $4 million estate. And I don't have a calculator in front of me, so I can't tell you exactly, but our estate tax percentages are 10 to 20% of the taxable piece of the Washington estate. And you get to 20 pretty quickly. So most people who have a Washington state taxable estate pay 20% on the amount that's over 2.193 million.
So in Washington state, though, each person has 2.193 million, correct?
Yeah.
So a $4 million estate, a
Yeah.
$4 million estate could be set up so that there was no estate tax. Is that correct?
Yeah, if it's between spouses and we do proper planning, then you can definitely avoid the estate tax. A common pitfall, I'll just hit on it really quickly, between spouses is that people know that they have an exemption each. So I know I have 2.193. My husband knows he has 2.193. And so we basically just say, okay, if something happens to me, I'm leaving it to you, and vice versa. And we just keep our plan simple because simple is best. But we do leave out one kind of important thing. And then it's fine when the first spouse passes away, we're never going to have an estate tax that is assessed at the time of the first spouse, because there are things that we can do from a tax perspective to take credits and elections and things like that. So there's not going to be a tax then. But the problem, if I've done that type of planning with that size of an estate, is that when the second spouse passes away, instead of holding their half of the estate, they're holding 100% of the estate, and we only have their tax exemption to use. Now we lost the first one at the death of the first spouse because we didn't use it. So that is something to talk to an attorney about. If you have an estate that's over 2.193 million and you're married, you want to have just the most basic form of estate tax planning inserted into your will or your trust, because you can avoid tax all the way up to almost 4.4 million between the two of you.
I just thought of a question, which is, what if a person, big estate, taking advantage of the exclusion, but they live in North Carolina and then they die in Washington? All their estate docs are based on North Carolina.
Mhm.
And yet they've moved to Washington and now they both die in that state. Does that make any difference?
Yeah, so when somebody does estate planning documents, I hope every attorney says it. I feel like they do, but we always say, if you ever move to another state, let me know and I can help connect you with an attorney there if you don't know somebody already, so that we can have these documents looked at. It could be based on the law of the other state. It's better just to overhaul your documents in the new state. Sometimes, sometimes I get clients coming from other places and I look at their documents and it's so close to what we would do here that we just do an amendment to what they already have to incorporate Washington law into it. But regardless, if you had documents, you lived in North Carolina, you had documents there, you moved here, you never went to see an attorney and you passed away, all states have an understanding that we will honor the documents of the person who passed away, regardless of where they were drawn up, if they're effective under our law. So if they were signed properly and witnessed properly, and actually it's the law of the state where they were enacted, if that was done properly, we'll accept them here in our state. And then there just may not be some shortcuts or some legal nuances that we would have in a Washington-based document. So we may not get advantage of a few certain things. But other than that, we'll do our best to make sure that the plan that they created in a different state still works here in Washington.
We just received another similar out-of-state question. It says, what if someone living in Washington has no heirs living in the USA, does not have a will or an estate plan? Are the living heirs German nationals living in Germany? What happens with the estate? Are the heirs living in Germany responsible for anything?
That is a complicated question. I'm just going to break it down to, you live in the United States and you don't have a will and you don't have any beneficiaries here. Everyone you want to leave anything to, or your heirs, so the people who are entitled to your estate because you don't have a will, live somewhere else. They can still inherit your estate. So that's answer number one. They would probably have to hire an attorney here to help them through the process, because they would most likely need to open a probate here in the state where the person passed away. And then once they did that, the attorney would file the appropriate things and they would go through the probate process. So, it's super inconvenient from another country to be doing that just because of language barriers and time difference issues. But it can be done. I've had cases before. I had a case where there was a man who passed away and he had a will, but his only heir and his executor, his beneficiary, was living in the Netherlands when he passed away and had become a citizen of the Netherlands. And so we did get him appointed. I did deal with the time difference issue with him and we did work everything out. It's just a little more complicated because there's not someone on the ground to be able to go in the house and clean that out or, do some of those typical things that people do, but it can be done. If you were in that situation, it would be a really good idea to have a will and to name someone in the United States who could just assist. But it's possible for anyone anywhere to serve as an executor.
Thank you, Brienne. That was from me.
Thanks, Dean.
Girl, I had that question the other day, so I should say Danke.
Bitte.
And who did your estate planning documents, Dean, if you wanted to share?
Well, there's this wonderful professional that delivered us great presentation on October 20th during National Estate Planning Awareness Week, whose initials happen to be BK. So
What a coincidence.
Isn't that something?
Mm-hmm.
Good validation.
Well, that's wonderful. If another break here and questions for just a minute, let me interject a few things about Leave 10 South Sound. We do not fundraise. We support all nonprofits with an interest in planned giving, and we offer supporting information and education to both nonprofits and professional advisors who want to increase their knowledge and ability to assist clients and donors in reaching whatever philanthropic goals those donors and clients have. All of the materials, educational offerings, online toolkits that Leave 10 offers are offered at no cost. All of our expenses right now are being covered by the generous support of our sustaining partners, Greater Tacoma Community Foundation, the Community Foundation of South Puget Sound based in Olympia, the Ben B. Cheney Foundation here in Tacoma, and the MultiCare Foundations. We are grateful for this local and ongoing financial support, of course. Any questions popping up yet? Then let me just drop in one more tidbit about Leave 10 South Sound. We have a very robust website, and you can reach it by simply typing Leave 10 South Sound into your favorite web browser. It has general information on the landing page and immediately useful materials and toolkits under the various tabs that are designated specifically for donors, nonprofits, and professional advisors. When you get the bug and want to officially join our initiative, go to the section on champions and sign up. Then go about talking to your friends and family, neighbors about this initiative. That's how we're making it pass. Just word one person to another. Questions? I think I saw something else pop up.
I don't see any other questions.
Oh, that I see. That was the direction to the website. Anyone else have a question for Brianne? It's this is your golden opportunity. The clock is not running.
Well, and I
It is
close
not
off my slide,
charging.
but if anybody is having more questions after this, feel free to reach out to me. I'll give you my email address. It's Brianne, BRIANNE, at Campbell, and it's Campbell with a K, and then it's like Campbell soup, but with a K, campbell-law.com. And you can also Google me and my website will come up, and there's a function to just message me right through the website. So whatever works for you, I'm always happy to answer questions and be a resource to you. And I really appreciate being able to talk to you today.
Well, if there are no other questions, we do not have to use all of this time that we've allotted. But thank you all for attending today. Leave 10 South Sound challenges you to imagine how we can positively impact the South Sound by completing this one act of generosity. Leave 10% behind to invest back into the community that helped us be who we are. Brianne, thank you again very much. Thanks everybody for attending. Have a great day.
Thank you.